Good afternoon, everyone, and welcome to Key Strategies to Reduce Litigation Exposure. Before we begin the presentation today, I'd like to thank our sponsor, Marin Marvel, Bradley, Anderson, and Tardy for today's webinar, and I'd like to go over a few housekeeping items. If you are seeking CLE credit for today's session, please make note of the 3 CLE codes that I will be putting in the chat box on your dashboard throughout that 1-hour presentation. Please make note of those codes as we will be sending an evaluation form after the presentation where you could put in those codes to seek your CLE credit. We will also be sending out the materials to everybody after the presentation as well. If you have a question for the panelists, please put that into the Q&A box and the panelists will address that question at the end of the session. I think that's all I have to say. I'm going to hand it over to Dan Alexander to begin introductions in the presentation. Dan?
Good afternoon, all. You're blessed with 3 presenters today. We're going to go in order, each take about 20 minutes of your time, and we'll try to keep you awake to the extent we can. Rob will probably keep you the most scintillated during this presentation. I'm Dan Alexander, a partner in Marin Marvel's Chicago office. John Robinson is in Dallas, Texas, and Rob Dill is down in New Orleans, Louisiana. I work closely with both these guys. The things we're going to talk about today are things that we all use, we coordinate on, and really, like the title says, we're going to talk about key strategies to reducing litigation exposure. You know, hiring an attorney necessitates some value added. If we as attorneys are not able to move the ball in a positive direction, you might as well just have your adjusters settle cases pre-suit for whatever the demand is. So these are some of the tools in the toolbox that we use to reduce litigation exposure, either lowering the amount of recoverable damages or in some cases, reducing down to 0. We've only got an hour. Each of us have about 20 minutes. So I've keyed in on 3 tools in the toolbox that I want to talk about. And at the end of my segment, I want to talk about one red flag issue that we're seeing a lot in the Midwest that can severely disrupt case values, irrespective of the facts. Now, what we're going to talk about is generally applicable across jurisdictions. You know, I'm based in Illinois, but I'm involved in defending cases in at least half a dozen jurisdictions, and we've gone to battle on these issues, you know, across the board. So if you have a specific jurisdiction question, feel free to reach out and we'll get that answered for you. Let's start, Rob. So number 1, attack medical bills and liens. Seems pretty obvious. Now, the traditional view of medical bills, which I don't personally subscribe to, is that case value is tied to these medical bills. Some people say 3 times medicals, 5 times medicals. You know, the adjusters get a case in 100,000 in medical bills. Oh, well, it's worth 4 times medicals, 400,000. While I don't subscribe to that, that is how plaintiffs' attorneys view things a lot of the time. And one thing we're seeing, especially over the past 3 to 4 years, is plaintiffs' attorneys leveraging this traditional view of medical bills to obtain higher settlements. And they do this by artificially inflating the amount of claimed medical bills. Plaintiffs' attorneys will literally control the medical treatment and work with chop shop physicians to control not only the numbers of the medical bills, but also the narrative, the causation, the necessity of the treatment. We see this a lot. A lot of the plaintiffs' attorneys, you know, it's a borderline scam, really. Let's go to the next slide. Review their tactics. Now, there's 5 steps that they need to kind of get this perfect scenario for them. Number 1 is the injury occurs and there's a lawsuit filed. However, this strategy really only works with 100% liability cases, like a rear end or something where they're pretty sure they're going to recover. Why is that? Because these chop shop physicians who operate on a lien are not going to put their hard work into a case and do these questionable surgeries and throw out these huge bills on a case with questionable liability, because potentially they get a 0 if there's an NG. So if you have a 100% liability case, even if it's very minor severity, you should be on the lookout for this. Let's go to step 2. Plaintiffs' attorneys refer the plaintiff to their independent medical treaters for extensive treatment. Now, there's oftentimes not a lot of documentation, right? There's no letters that typically go back and forth. Usually it's a phone call, but that makes it a little bit harder to discover what's happening. Sometimes they use what's called a medical concierge service. For instance, MMI, which stands for Maximum Medical Improvement in Chicago, is sort of a behind the scenes company that plaintiffs' attorneys will call and say, we have this, this, and this. What doctor can we go to? And then MMI puts them in touch with these chop shop physicians that are often same day surgery clinics where they're getting injections for 40 grand a pop. You know, anything above 10 grand obviously should raise a red flag. It's really hard. It's really, really hard to dive in on these medical concierge services like MMI. You know, when you have the perfect storm, you can do it, right? You need, number one, a great judge. We had Kathy Flanagan in Cook County for Illinois folks who are familiar with her. She's a bulldog and she helped us here. We had an aggressive client that provided us the rope to press the right buttons. And we had a pretty inattentive opposing counsel that kind of failed to get protective order. So this is how we initially kind of ripped the Band-Aid off of MMI and got under the hood. These chop shop physicians, they don't get referred to by these emergency room or primary care MDs that are treating like an initial injury. You're kind of like, how did they end up getting to these people? So you want to explore the genesis of the treatment. So there's a connection there. There's always a connection, but usually it's not documented. Let's go to step 3. Of course, all these medical treaters always opine that the injuries are caused by the occurrence at issue, and they lump in all the treatment that happens. In addition to causation, they say it's necessary. And these are a lot of times when an injury is of questionable necessity. You know, they might have had prior herniations. Now they're saying, you know, he needed this injection, he needed that injection, he needs a surgery, he needs a future surgery. They lump all of it together. You know, as you know, most of the good doctors are there to treat the symptoms and treat the injury. They're not out on a hunting expedition to figure out why this happened. Well, these doctors are always very sure what caused this, and they even rule out other causes. Let's go to number 4. The medical treaters issue bills, in quotes, with egregiously inflated figures. These bills are not paid by their private insurance or any governmental payer, even if they're covered, even if the patient has Blue Cross Blue Shield. Blue Cross Blue Shield is not billed. And as we'll get to, it depends on states. In Illinois, they have a year to submit insurance. They're not even submitting to insurance at all. The amount billed is typically not tied to any benchmark, and they range from mildly egregious to horribly egregious. And they commingle facility fees and professional fees. You're probably familiar. For instance, at the same day surgery clinics, the actual facility that employs the nurses and provides, you know, the bed and the rent, that would be a facility fee. And then there's professional fees for the surgeon, and oftentimes the nurse practitioner has a separate bill. If there's an anesthesiologist, he'll have a separate bill. So facility fees and professional fees are all different. Oftentimes the doctor who's issuing the professional fees, the chop shop doctor, will also own the facility, and they'll double bill for things. All these bills, all these figures, sometimes, you know, nearly $1 million or more than $1 million, are rolled into a lien that's contingent upon recovery in the personal injury matter. Let's go to step 5. Whenever a case settles, the plaintiff's attorney and the medical treaters work together to divide up the settlement funds, and the liens are inevitably cut to a level that's somewhere near realistic, yet still way more profitable for the physician than private insurance. The plaintiff's attorney wins because they have this huge number to throw out there. And really, typically, the defendant and their liability insurer never know what is ultimately paid. You know, we have testimony from various chop shops that they actually have a representative, you know, billing personnel in touch with plaintiff's attorneys during a mediation. The offer is this. We can get you this. We can get you that. It's a coordinated thing. And typically they're not emailing, but they've made some mistakes and sent some emails. Let's go to the next slide. The end game, defendants are pressed into paying more via settlement due to the bigger sticker price of the medical bills. Now, it's not always the case that medical bills are inflated. Obviously, if you're treating at a flagship hospital, it's unlikely that that's occurring, but you really need to take a fine-tooth comb to it. Let's go to the next slide. Admissibility of medical bills. It's jurisdiction dependent, but there's typically 3 ways in most jurisdictions that you can establish admissibility. If they've actually been paid, if an expert testifies that they're reasonable, or if they're stipulated as reasonable. Most cases settle, so a lot of times plaintiffs' attorneys don't worry about admissibility. And admissibility is an easier thing to fight, but it doesn't fight everything we need to fight when we're talking about medical treatment. The three different battlefronts that we use in our defense tactics will be fighting on causation of injuries. Did this occurrence cause this injury? Necessity of treatment based on the medicals. Was this really necessary? And three, the amount reasonable of medical bills. When we have an opposing counsel using the tactics that we just described, we can actually cut away at all those. We can cut away at causation because the way that they operate, takes away legitimacy from what they're doing. So let's get into defense strategy. Next slide, please. Right off the bat, you need to research the approximate reasonable cost of the various providers before embarking on this process, right? The process costs money, not a ton, but if there's $10,000 in medical bills, even if it's egregious, you're not going to fight it, right? Once we start to get over 100, maybe you're going to fight it. When you have over 1 million medical bills, you really have to pay attention to this. So this is the starting point in determining whether to engage in an aggressive defense on these fronts. How do you research it? Well, there's a number of ways. Typically, the large flagship hospital systems will have their charge data master documentation on their websites. And workers' comp reimbursement rates are a good benchmark for what's reasonable. Let's go to the next slide. All right. Once you realize, hey, there's something tricky about these medical bills, you retain an expert to conduct a UCR review. That means usual, customary, and reasonableness. And the experts, we've used a couple of them. We have one go-to in particular that gets us out the door for about $3,000 to $4,000 per plaintiff. So it's not a huge spend, and you can really knock things down quite a bit. But they use a combination of objective database information and then subjective expertise to kind of round things out. A couple examples of major knockdowns are right there, but it's not really that hard for them if they are in fact egregious. Sometimes they'll call you back and say, these are just a little inflated, not enough to make a huge deal out of it. Now, in the right cases, the experts are not limited to this UCR, this usual, customary, and reasonableness. Some of the other things they can opine on that really help us is what's called NHC. That's nature of health condition. And that is when they say this bill is not even related to the injuries that are caused, right? And we can do that, but it helps a lot to have an expert also throw that into their report. Another front that our experts can fight on is hammer compliance failures of these medical practices. It cuts away at their legitimacy and has real relevance to the case. For instance, like I mentioned earlier, if they are failing to report to insurance, and the plaintiff's private insurance expires for the claim, the patient can never get that back, right? They can't send it to BCBS 4 years later when there's a not guilty. Now, on that front, you have to be careful because you don't want to paint the plaintiff as a victim and say, like, the plaintiff's attorney and this doctor took advantage of plaintiff. So you don't want to hammer that unless it kind of is cohesive with your case. Other thing is, by operating on a lien, our experts can say, look, they avoid insurance audits. When you submit bills to Blue Cross Blue Shield, they will audit it, they will cut things. That process doesn't happen with this technique. They also will notice double charging, and they'll review all the facility fees, the professional codes. So it's not just limited to bringing the total amount down, but it's poking holes in these chop shops. I have some publicly available expert disclosures that are, not confidential. They've been used in cases. Feel free to email me. I can give you an example with some redactions, but kind of what an expert disclosure looks like that touches on a bunch of different issues. Rob, let's pop to the next slide. Number 3, this would be conducting written discovery that is specifically tailored to these issues. That would include communications, emails, correspondence with plaintiff's counsel, and the medical treaters. The CMS 1450 is the facility fee that the same day surgery bills for. The CMS 1500, and that's a typo, would be the professional fee that the various doctors and nurse practitioners will use. The charge data master is a spreadsheet that literally shows what is charged for every procedure down to, if a bolt is used in a surgery, there's a charge for that. Oftentimes there's contracts between the patient and the medical facility that there's a lot of gold in there. Communications, you know, oftentimes plaintiff's counsel won't disclose it, so sometimes you need to issue a subpoena on the other side. And then liens. Now, a lot of times the lien holder is not the actual physician. They love to sell their liens. One of the companies that's buying up liens is Omni Financial. Now, anytime you fight them, they always hire counsel to fight you back. It's judge dependent how deep you can go, but you want to get the sale price of the lien in order to bring down the reasonable cost. You know, we haven't gotten to the stage where we've determined whether a trial judge is going to let that specific issue in, but it can only help to attack Omni Financial. Next slide. Issue detailed subpoenas to medical treaters, right? You issue subpoenas, but you want a subpoena rider that specifically seeks things that are outside the scope of just medical records, bills, surgical reports. You want all those things we were discussing earlier. In my view, the good judges have let this sort of stuff in. Oftentimes, you need a motion to compel. In great scenarios, what we've gotten are emails between plaintiff's counsel and billing personnel for the practice where they're discussing liability. The medical office personnel are actually requesting accident reports from the plaintiff's paralegal. Why would they possibly need an accident report? Well, it's because they're not going to run the chop shop drill unless it's a liability case. The liability facts, for the most part, do not matter at all to what the doctor is going to do to the symptoms. Next slide, please. Depose the corporate representative or person most knowledgeable for the billing practices of the medical treaters. You know, whether it's federal court or states, there's usually a corporate representative statute where this individual speaks for the company and binds the company. Sometimes it's the actual surgeon who is doing it. And in that case, I mean, the surgeon will usually get the game if it's his own company and he's like dealing with the financial issues. Sometimes for the bigger chains, it can be the CFO or the billing manager. They're often represented by counsel, but there's unfavorable admissions that you can force them into just based on the nature of this. The best case scenario is when there's some unprepared billing person that's designated as their corporate dep. And that's like getting a lamb being led to the slaughter because a completely unprepared witness will give away the farm. For instance, we've done this before just a couple months ago, had somebody under oath, and they're saying, well, the reason that we operate on a lien as opposed to billing Blue Cross Blue Shield is because we make more money when we operate on a lien. The recovery is bigger. I mean, that's enormous. It's enormous evidence that has a bigger impact than just how much are the medical bills. It brings everything into question. Because another thing that you need them to admit is their recovery is contingent upon success in the underlying case. Other things like the last bullet point there, the medical practice never really sues the patient, even though in the contracts that they sign, they're supposed to if there's a not guilty and then they don't pay. Next slide, please. Once you kind of get a database, and we have a good amount of transcripts, at least in the Midwest for the worst offenders, you can compare evidence between cases. And it's important to remember that these under oath transcripts from corporate representatives are admissible in other cases, right? And we're going to talk about that a little bit later. But, you know, they'll fight them. Sometimes they'll file protective orders. It's worth trying to fight those at every turn. Next slide, please. And then, like I discussed, aggressively pursuing the medical financing and the medical concierge services via subpoenas, depositions, written discovery. Medical finance, either they're fronting the money or buying up the debt. That is of questionable relevance, right? Sometimes they'll keep that out. Medical concierge, connecting plaintiffs' firms with medical treaters, like I discussed earlier, is enormous evidence. Got to get to the bottom of that. Plaintiffs' attorneys are actually paying these concierge services. Once we get that connection, it's a game changer. Like I said, you need the right state and the right judge to complete this tactic because you might get blackballed. All this can be wrapped up via our medical billing expert to kind of lay out a story. And especially if there's good things tying the individual, you know, if there's prior medicals that kind of make it clear that they're aware of this game, that's the best case scenario. Let's go to the next one. Our 3 goals as I mentioned earlier, cut down the amount of medical bills, establish bias on behalf of the causation opinions of these medical treaters, and then call into question the necessity of medical treatment. Oftentimes, you can settle below the claimed medical bills using these tactics. I mean, we've had cases with 750,000 plus in medicals, and once you establish, all their work is with personal injury firms, and 20% of the time they work with this particular plaintiff's firm, and yeah, they usually cut 80% of their bill to facilitate settlement. You settle a lot lower. It's not a rare thing, and really it should be the expectation, unless the injuries are like completely legitimate, to settle for below what they're going to blackboard, even in 100% liability cases. Let's go to the next slide. So the summary: plaintiffs' tactics of inflating medical bills are becoming more and more frequent. They're kind of clawing to raise case values as much as they can. And the bottom line, and I think a lot of you know this, but we should never just accept the claim medical bills. Oh, it's 350,000 in medical bills, so that means it's going to be. No, we need to dive in. We need to look at what was done. We need a benchmark to begin the process to figure out, is there something going on here? Let's go to the next one. Topic number 2, judicial estoppel, dismissing a case for inconsistent representations. This is a beautiful tactic, and I'll use Illinois as an example, where you can zero out somebody depending upon other representations they've made. Everybody does background checks and miscellaneous investigations of plaintiffs when they get a lawsuit in, right? That includes pulling the federally available bankruptcy docket, seeking their health insurance history, seeking their Social Security earnings, looking at what workers' comp cases they've filed and pulling the arbitration transcripts from those, looking for disability hearings, looking at litigation, in a property case with other property insurers, for first-party insurers, anything where they are making representations in under oath or in a quasi-jurisdiction judicial proceeding. Now, these can help. You can find favorable evidence, you can impeach at trial, you can get ammunition for motions in limine, you can get adverse inference instructions at trial, but the best option is obviously when you can extinguish exposure altogether. Let's go to the next slide. All right, there's 5 elements generally for judicial estoppel, and pretty much this is just you lied under oath in a different case. But here's what you need: 2 positions, factually inconsistent, in a separate judicial or quasi-judicial administrative proceeding. So it doesn't need to be another deposition transcript or anything. Quasi-judicial administrative, like a disability hearing, will count. Intending for the trier of fact to accept the truth of the facts alleged, and you receive a benefit from it. Let's go to the next slide. I don't have a ton of time to walk you through the examples, but I will walk you through a typical example. And even in Cook County, if you get a good judge like Ehrlich, you can zero somebody out on this. So in 2017, guy at a construction site sustains a serious injury. Okay. Goes along in 2018, he files for personal bankruptcy, does not include his potential lawsuit as an asset. The bankruptcy goes on however long, it could be 18, 19, 20, and that debt is discharged. Okay. When you fill out bankruptcy forms, there's a specific question, there's a line item. Do you have any pending or potential litigation? And you have to disclose the approximate value of that. And your bankruptcy attorney has to ask you about that. Okay. After this happens, or during the bankruptcy, the plaintiff files a personal injury lawsuit. Okay. But that's why you search the federal bankruptcy dockets, because if this personal injury suit was not disclosed as an asset and debt is discharged, you can get dismissal of the entire lawsuit under the doctrine of judicial estoppel. This also works in demolition or excavation cases, like when in their dealings and litigation with a property insurer. Workers' compensation can be used. There's a lot of examples, and we've had some good success with this. It can also cut away a part of a case if you're not going to get the whole thing. So next slide, please. The third and final one is federal removal. I think a lot of folks know how you get to federal court, right? It's diversity jurisdiction. The parties need to be completely diverse. No plaintiffs and no defendants are from the same state, and the amount in controversy has to be over 75,000. Every defendant, for the most part, would prefer federal court we are probably more impacted than most because Cook County, our home jurisdiction, is just brutal for defendants, but typically you want to be in federal court. And diversity of jurisdiction is a good way. Next slide. However, one thing that can keep you in, even if you have the amount in controversy and complete diversity, is this forum defendant rule, which provides a civil action otherwise removable may not be removed if any of the parties are properly joined and served as defendants as a citizen of the state in which such an action is brought. Now that joined and served language is really, really key. Okay, let's go to the next slide. A defendant to stay in a state, a defendant has to actually be served with a lawsuit. So this incentivizes a race to the courthouse. Okay, if you can remove a case before the in-state defendant is served, but after an out-of-state defendant is served, and it doesn't necessarily have to be after, the court will deny a motion to remand. So let's go to the example on the next slide. All right, we're in Illinois. A lawsuit happens here. They file it in Cook County. The plaintiff is from Indiana. The defendants are from Ohio and Illinois. Typically, this can't be removed because there's an Illinois defendant, and the forum defendant rule prevents that. However, if you file a notice of removal before defendant B is served, you can get it to federal court. This is why people monitor litigation dockets to bounce things right away to get a better shake at it. This is certainly a hack to the system, certainly is, but it works. We've litigated this in federal court. We've won. We have good opinions that we cite as persuasive opinions in other cases. Let's go to the next slide. All right, last little topic. This is a red flag issue. Everybody knows joint and several liability. And if I had more time, I could talk for an hour just on this. But some states have several liability, like Indiana, where you don't have to worry about this. In Illinois, it's typically 25% joint and several. However, it's 1% allocation of fault gets you 100% of past and future medical expenses. It's called the 1% rule here in Illinois. But if you can peg a defendant with 1% liability, you can get all the past and future medical expenses. So in a case with enormous life care plans and two defendants, right? You're insured who has very little liability, but big insurance, and a co-defendant who has all the liability, but not enough insurance. The plaintiff's attorney can say, yeah, the other party caused everything. They should be 99% at fault. But this guy over here, they're not really liable. Just give them 1%, no big deal. And the jury does that, 99 to our co-defendant and 1% to us. We will be liable for the entire life care plan, which could be in the millions. And the worst part, the jury never knows that they're tagging you for millions and millions of dollars by giving you that 1%. If you have more questions on the 1% rule, shoot me an email. I can send you more stuff, but it's really, really insidious. It's really, really unfair, and it's really, really terrible. I went over my time, but I'm passing along to John. Thanks, folks.
Thanks, Dan. As Dan said, my name is John Robinson. I am also a partner in the law firm of Marin Marvel, Bradley, Anderson, and Tardy, and I work out of the Dallas office. And I'm going to continue our discussion of reducing litigation exposure by talking about a particular issue that is called risk transfer. And Rob, let's go to the next slide. Now, risk transfer, what we want to do is when a case comes in and it gets into litigation, you can look at three areas to transfer the risk for your insured or your client. You can look to the other parties that are in the litigation. You can look to the contracts and agreements that exist not only with your client, but with other parties in the litigation. And you can also look to the insurance policies at issue in your case. The bottom line is that can the liability, the defense, the litigation costs, and the obligations of your insured, can they be transferred to someone else? Let's go to the next slide. Talking about other parties in the litigation. When a case, if the case is in litigation, take a look at your other defendants in the case. Can the risk, can the responsibility for the plaintiff's injuries and damages be transferred to them? And that can be done through a cause of action for contribution against your co-defendants. We've had plenty of situations where we've been a defendant in a case, but by and large, it's been the other defendant in the case who bore the responsibility in large part for the plaintiff's injuries. In fact, we've had a case where our experts said it was 100% the other defendant's responsibility. And so during the course of the litigation, what we did is not necessarily, while we built our case against the plaintiff, we focused most of our efforts in directing and developing our case against our co-defendant. You can spread the litigation, you can spread the risk to other parties within the litigation. But it's also important to note to not only who your other defendants are in the case and whether or not the risk can be transferred to them in the form of a cross action for contribution, but looking to see who's not there. Is there a party that is in part, in whole or in part, responsible for the plaintiff's damage, injury, and harm who's actually not in the case as yet? Be careful on this because sometimes there are scheduling order requirements, there are procedural requirements in your jurisdiction that call for when you can add parties to the case. But certainly at the beginning of the case, look to see who's not there. And if there's a party that bears some responsibility that should bear some of the risk and to whom that risk should be transferred, talk to your local counsel about drafting a third-party petition to bring them in as an active party to the case. In Texas, we also have a tool called responsible third parties, where you don't have to bring the responsible party in as a viable defendant, but you can designate them as a responsible third party. And if you're able to establish their negligence and fault, you can have their negligence and fault submitted to the jury. Now, this is really important in a lot of contexts. For example, in the oil patch, you quite often have service companies come onto the premises and one of their employees gets hurt. And I've represented owners of these oil rigs and they end up getting sued. The plaintiff in that case cannot sue his employer because of the workers' compensation bar. So they sue the owner, my client. In Texas, you can designate the employer as a responsible third party, even though there is a workers' compensation bar. In this particular case, it was quite obvious that the service company had not trained this plaintiff, had not properly equipped this plaintiff, and they bore a significant amount of responsibility for the plaintiff's injuries. And we were able to designate them as a responsible third party, even though the plaintiff himself could not sue them because of the work comp bar. In addition, Texas allows you to designate unknown parties as responsible third parties. I'm handling a case right now where intersection collision, but what happened was somebody ran the light. Some guy was driving. Our experts anticipate he may have been going as fast as 85 miles an hour, ran the red light, caused my truck driver have to take evasive action, ultimately striking the plaintiff's vehicle, causing some serious injuries. We designated this unknown John Doe as a responsible third party, and we hope to have his negligence and causation submitted to the jury. Texas allows this under the responsible third party procedures. And so it's important to check with your local counsel to see if your jurisdiction has something similar to that. In Texas, we can also designate bankrupt parties. So even though a party who may have some responsibility has filed for bankruptcy, in Texas, we can still designate them as responsible and still have their fault submitted to the jury. So you can spread the risk to your insured and to your client through other parties to the litigation by cross-acting against defendants who are in the case and bear some responsibility, adding new parties to the case who have some responsibility, and also utilizing, at least in Texas, a responsible third party statutes to bring in other individuals and companies. And finally, don't forget about the plaintiff himself. I consider it a manner of risk transfer to file a contributory negligence affirmative defense, arguing that the plaintiff himself was responsible for their damage and harm, at least to some degree. So these are the ways that you can transfer the risk in a case within the litigation context. Rob, let's go to the next slide. Another inquiry you should make, especially early on in the case, is whether or not another party has agreed by contract to accept the defense and indemnity for your insured. Now, you do this by examining the contracts and agreements that are at issue and that are relevant to your client's case. This has an enormous impact in a variety of different types of litigation. In premises liability litigation, I represent the owners of a shopping mall. Quite often, we have slips and falls, boxes falling on people within the tenant's premises. The tenant always gets sued. And of course, my client always gets sued because they're the owner of the premises. But when you look at the lease agreement entered into between the tenant and my client, there is very clear contractual indemnity, and they are responsible for our defense and our indemnity under the lease agreement. In the oil patch, in that example that I gave about the Joe plaintiff working for the service company who gets injured out at the oil rig and sues the owner of the oil company. In the oil patch, they're generally known as master service agreements. These are the agreements that exist between the service companies and usually the owners of the oil or of the oil rigs. Check those agreements out, because quite often they also have contractual indemnity provisions. As it turns out, in the case I was handling, the GL carrier for the service company ultimately took over the defense of my client, the owner. And we were able to completely transfer the risk of that case to another party based on the contract agreement. Also, if you are handling cases in the construction industry, especially if you're if your client or your insured is the general contractor, and you've got a claim either for construction defect or you've got a claim for personal injury that occurred on a construction site, make sure you get a complete copy of the construction contract that existed between your client and the subcontractors, because quite often, in order for a subcontractor to come onto a job site and perform work, they've got to sign a contractual indemnity provision that is a part of their contract. And you can tender the defense to the subcontractor in many circumstances. So make sure when these claims come in and you're doing your evaluation and you see that it's a certain type of case where these agreements are going to be relevant, reach back out to your insured and get copies of these agreements and take a look at them. Get them to your local counsel and get them to review them and determine whether or not you can actually transfer the risk based on the contractual language that exists. Rob, let's go to the next slide. Here is a typical contractual indemnity provision. Now, contractual indemnity provisions usually run two different ways. One, there is a broad form, and these are broad provisions for contractual indemnity that call for defense and indemnity to the party, regardless of who's negligent. The more narrower form is a contractual indemnity provision that provides for defense and indemnity only to the extent that the party who's doing the indemnifying was negligent. It's the difference between broad and narrow. Now, it's very important that when you look at your client's documents, your insured's documents, and you see this type of language, get this over to your local counsel, because every jurisdiction is going to have their own rules about the enforceability of these provisions. In Texas, these provisions must be conspicuous, which means they either need to be in italics, they need to be bolded. There may be a difference between broad versus narrow. So when you see these provisions, and I know I've seen them in the past and gotten very excited, but when we took a closer look at it, we found that they weren't enforceable. Many states and many jurisdictions do not favor these broad forms. So when you see these provisions and you get excited about being able to transfer the risk, make sure you have local counsel review them to check on the enforceability of these provisions. So here we have risk transfer by reason of contract. Is there a transfer of risk due to the contractual agreements between your client, your insured, and other parties? Rob, let's go to the next slide. One of the other areas to take a look at in terms of transferring the risk also has to do with these contractual agreements. Quite often, your client, your insured, is also required by contract to be named as an additional insured under the contract. For example, In one case that we dealt with as a premises liability owner that I was representing, we tendered to the tenant to take over the defense of the claim. They proffered this argument about the contractual indemnity provision, had some issues, etc., and argued about its enforceability. Well, we pointed out that regardless, we believe the provision was enforceable, but regardless of that, we're to be an additional insured under your policy. So when you see claims like this, when you see language like this in a lease or a master service agreement, contact your insured, get a complete copy of the agreement, and also through the discovery process, get copies of the insurance policies that are at issue in the case, and then make your tender based on this language. The other thing I want to mention, because it's come up in a recent case, is you'll notice one of the language in this particular contract, and it is in quite a few of the contracts that we've taken a look at, that the contractor shall provide a blanket waiver of subrogation in the company's favor on all policies as well. And this turned out to be of enormous value in settlement negotiations, because in the oil patch, for example, in my case, the plaintiff had a large workers' compensation lien. And quite often in settlement negotiations, you start to get close to a number, and then the impending shadow of the workers' comp lien comes in. We've got to take care of this. Well, not if you've got a waiver of subrogation in the contract. We also had that in our premises liability contracts with our tenants. There is no subrogation. No comp lien needs to be taken into account when handling and resolving a case with these types of provisions. So just keep that in mind. One other issue also to keep in mind is concurrent insurance policies. For example, we've had a situation where H2S, which was a hydrogen sulfide gas exposure, caused an individual to fall from heights and be seriously injured. Well, the pollution carrier was put on notice because of the H2S. The GL carrier was put on notice because of the fall from heights, and both of them argued about which one was really going to be responsible. To my surprise, they worked out an agreement that they just simply, we're going to share this 50-50. So there is transfer of the risk that can be had in looking at these insurance policies, in looking at your contracts. Now, go to the next slide, Rob. We've talked about how to transfer the risk in the context of litigation. You accomplish that, you make that happen through cross actions for contribution, third-party petitions, and designation of responsible third parties. How do you make this happen in these other contexts? You do it through the use of tender letters. Those tender letters can be drafted by the carrier, they can be drafted by your counsel. What they basically are demands, attaching copies of the policies, the contracts at issue to other parties, demanding that they take over the defense and indemnity. And if these issues are out there, recommend that you get involved in these early, because quite often when a carrier does in fact agree to accept the tender and starts to pay for the indemnity and starts to pay for the attorney's fees and costs, they only agree to do so from the date that they receive the tender. So get these out there as quickly as you can, as quickly as practical. And finally, keep after them, because quite often you'll make a tender and it will be weeks will go by, and then suddenly it's 6 months and you haven't had a response. And then you reach back out to them and like, oh yeah, we'll take a look at that. We recommend that when you make the tender, calendar your file for 30 days. Reach back out to them and get your counsel to write a second letter or a third each and every time, usually getting a little more angry with and insistent on a response. So get those tender letters out there, get them out early, and keep after the parties that you're seeking the tender from. So the other practice tip, get full and complete copies of the contracts and the insurance policies at issue. And as we've said, read the fine print. Quite often you can find great avenues to transfer the risk from your insured to other parties. Thanks, and I'll turn it over to Rob Dill.
All right. Thanks, everybody. Hopefully I can talk and run the presentation too. My name is Rob Dill, and I'm with the New Orleans office of Marin Marvel. And I'll be talking today about another way you can reduce your insurer's liability, and that's simply confirming the plaintiff's story as one title, or liar, liar, pants on fire. So as you can imagine, we're going to be talking about plaintiffs who perhaps aren't entirely truthful, one in particular. And I think the takeaways that I think you'll have, that certainly we had from this case, was to be appropriately skeptical when you're dealing with any case. Maybe not question everything, but appropriately skeptical. And then if any red flags come up or yellow flags come up, investigate them and make sure there's nothing there that can indicate the plaintiff is not telling the truth. So what we're going to talk about is a case of Rosemary Wilkinson and Cayman Realty. And Cayman Realty was our insured, and this is a case down here in Louisiana that we handled last year. Accident is very straightforward. It was a slip and fall at the Rouse's supermarket in Baton Rouge, Louisiana, a little town north of Baton Rouge. Miss Wilkinson, Rosemary, was leaving that exit and walking straight toward the camera. She was pushing her buggy, and the buggy wheel got caught in that spot that you see on the screen, and her buggy pitched forward and ended up like this. Unfortunately, she pitched forward too and ended up on top of the buggy. She was 22 weeks pregnant. Later on that night, posted this in social media, just describing the accident and apologizing to the folks there that may have been hindered by the emergency vehicles that showed up. So my point here is twofold. One, she likes social media, and you'll see that very shortly. And two, the facts of the accident, as far as we know, happened just like she said they did. She reported it to the manager, so everything's fine there. We litigate the case for a couple of years. And you ask why that long? Well, COVID was a big delay, and scheduling was another delay. But we finally got her deposed, the appropriate people deposed. We got the medical records. We went to mediation. And by the time we got to mediation, which was 2 years later, this is what she was saying. And this is in May of 2021 when we mediated this case. She was still, despite being 2 years post-accident, complaining of performing daily activities, including grooming, cleaning, cooking, yard work. She said that she had to alternate positions and in fact had to limit her activity throughout the day. The posture, the mediation was not successful. And here's the posture when we left mediation. The plaintiff was at $475,000. We had offered $150,000. And so we left. This mediator, we were clearly in different universes. This mediator is one that works the case afterwards. He was really good in following up. And so he continued to talk to the different sides and didn't get anywhere. But there was a point where he said, look, here's what I would like y'all Cayman to do. Get up to 225, make the plaintiffs turn that down. But at the same time, he told us, look, I don't think they're going to take it. That he thought the plaintiffs were in the mid 300s. Okay, so that's the posture when what I'm about to go over happened. A wide gulf between the two parties. So Rosemary's social media was just always troubling, and when I say troubling, I mean it was there and it didn't match exactly the picture that the claims painted. It wasn't opposite, but it just didn't fit. For example, she was claiming some economic damages that she couldn't. She owned a massage business, so like a massage, not a massage parlor, but a massage and relaxation business. And she said, the injuries prevented her from working as much and hurt managing the business. Well, her social media posts were very positive, thanking all of her friends for frequenting her establishment, the blessings that she had gotten from, all this business. So it wasn't directly contrary, but it was not just fitting with the picture she was painting in the litigation. Then we have the post of May 24th, 2021. Now this was about a week after the mediation, I believe. And the post title was thriving at 37. I'm going to play a short clip from the video that she posted. That's her husband admiring. All right, so Rosemary truly is thriving at 37, it appears. I'm thriving at 52, but I think I'd have to do about 10 minutes of stretches before I could pull off anything like that. So that gets posted on the 24th, and we show that to the mediator. We say, hey, here's what she just posted. Do you think this could perhaps help bridge this gulf? We know she sustained an injury, but it's not what she's claiming. See her thriving at 37. So the mediator presented it to the plaintiff's attorney, and we got an explanation. Rosemary said, no, that was an old video. She just happened to post it recently. So we say, okay, all right, well, now here's where the skeptical nature comes in, and really being tenacious. And it was a combination of the associate working on the case with me, Nick, and the claims professional. Both hand in hand were going over these videos that I'm about to show you, and they uncovered everything that I'm about to show you. So when I say we, I mean them. And it's not just our firm, it was working hand in hand with the claims professional. So they took a look, they took a look at the video that I showed you, and other parts that I didn't show you, and they saw this. And so what is this, and why is that important? Well, it's important for that. It's a mask. Now remember, this is May of 2021 that she posted this video, and she's telling us, no, it's several years old. It's back in 2017. So as we all know, in the spring of 2021, there's plenty of masks, particularly at wedding receptions. In 2017, there weren't nearly as many masks, maybe a one or two in airports, but certainly not in wedding receptions. But so we pointed out the mask, and we said, what's the explanation for this? And we got another explanation. She said, no, look, that was at the Dunn wedding, D-U-N-N, and it was worn by Miss Dunn, my friend, grandmother, who had had cancer treatment. And so when she's in public places like that, she had to wear a mask. And she went on to say, why don't you call Dunn and confirm that for yourself? So she was nice enough to provide her attorney with Dunn's phone number. The plaintiff's attorney, who I knew, called up Dunn, passed along the number to us and said, look, I called her. That's what she says. I confirmed it. Why don't y'all call her up? So that's what we did. And so Nick called Miss Dunn. Miss Dunn said, everything that Rosemary said is absolutely true. The wedding was in 2017. The grandmother was there with a mask, and she added, that was just Rosemary being so crazy at that reception. I remember it like it was yesterday. She went on to say the wedding was at the Crown Plaza, and we moved the reception to the Addis Community Center. And so when Nick and I went over those details, we said, you know what, that's something, that's a yellow flag. It's odd to have a wedding at a hotel and go to somewhere else for the reception. So that was a yellow flag that we needed to figure out. So we started looking into, they started looking into this Dunn wedding. We found out, yeah, it was in 2017. That was true. But social media is a wonderful thing. They've got a YouTube video of the Dunn wedding, but it showed that it was at a different location. So we had the invitation. We see the wedding. That's a church. That's not the Crown Plaza. And then there were some videos of the reception, not at the Addis Community Center. It looked very similar, but we knew it wasn't. So again, more unraveling. And here's where the investigation really got good. One of them went on the Addis Community Center Facebook page and just started looking. And they found a wedding in a month before the mediation. And remember, this is 2021 spring, not many weddings happening then. So this one kind of stood out. So they saw that on the Facebook page of the Addis Community Center. They figured, they went to the lovely couple, the Scotts, Maurice and Jared Scott, they went to their wedding page. They learned who their wedding photographer was, found the Instagram page of their wedding photographer, and they were scrolling through the Instagram page. One of the things they noticed was that one right there in the center. I don't know if you can see my cursor, but it's right here in the center. And in the background, it looked a lot like the video recently posted by Rosemary Wilkinson. Remember, she said that was in 2017. This Instagram page post was from a wedding in 2021. All right, so they click on the video, of course. I'm going to show you what they saw. Lovely video, very well done. The photographer is very talented. If I ever get married again, maybe I'll call him up. But what the striking thing was what's in this frame. And if you look to the top right, again, I don't know if you can see my cursor, but sitting in the top right of that picture is Rosemary Wilkinson. Well, it's someone that looks a lot like Rosemary Wilkinson. And so the venue's the same, okay, as the Rosemary video. That was the question. Is this Instagram video from a month ago, is it the same as what Rosemary said was 4 years ago? That's the question at this point. So we know the venue is the same. The people were the same. They started comparing these two videos, supposedly 4 years apart. The people were the same. They were wearing the same clothes. The decorations were exactly the same. And Rosemary's at the same table wearing the same outfit. So what happened? Well, reminder, the plaintiff is at 475, Cayman's at 150, and the mediator wants us to meet in the middle somewhere and thinks it's going to take 300. We took all the information that I just told you about, and I explained it to the plaintiff's attorney. And I sent him links. I told him to go look for himself, but I told him exactly where to look and what to look for. He called me back a little later and he says, "Rob, I understand what you're saying, and I'm gonna sit down with Miss Rosemary in person and get her explanation of this so I can hear it from herself, from himself." So he did that, and he was going to do it that evening. And the next thing we hear is we get a call from the mediator asking, can we still have the $150,000? So the key takeaways here, again, I said them at the beginning, is to be appropriately skeptical at the right times and on the right things. And then if something just doesn't seem right, spend a little time and figure it out. If it's a yellow flag, if it's a red flag, determine if the story seems reasonable. And if it does, move on. But if it doesn't, keep digging. Being tenacious like that with the plaintiff's story almost always pays benefits in some form or fashion. And every once in a while, you're going to get a case like this where it paid dividends to the tune of probably several $100,000 that we would have eventually spent to settle the case, if not try. And who knows what would have happened then. So that's it from my part of the presentation. And I guess I think I'm going to throw it back to Amy to maybe send out some questions.
Well, there were no questions from the audience today. If the panelists would like to make any last comments.
No, everybody can look us up on our website. If you have any questions or would like to follow up, shoot any of the three of us an email, or all three of us. But we appreciate the time that everybody took out of their day to attend, and Amy and Perrin will square away the CLE for you.
Yep, absolutely. So I'll be sending out evaluation forms and the materials to you, so you can. We do have the one question. Did you accept the 150K settlement?
Oh, good.
I was wondering that too.
Yeah, we did. And the reason is because we thought it was fair. It was what she thought. She was injured. We thought everything, recent was unfair. And so ultimately, yeah, they did. We made them squirm a little bit for a few days, but we ultimately accepted it. Great question.
Well, thank you very much to Marin, Marvel, Bradley, Anderson, and Tardy for sponsoring this webinar today. And we look forward to seeing you at future parent conferences and webinars. Have a great afternoon, everyone.
Thanks, everybody.
Thank you.
Thank you.
Guys.